Paul. I'm just wanting to make sure that there's some understanding about what it means to be unable to obtain a lawyer without causing substantial hardship. It isn't that the public defender is intentionally causing financial hardship to myself or my family because of being homeless. You know, when you do these court-ordered mental health evaluations and you don't admit any evidence, you won't allow me to call any witnesses on my behalf. I had emailed the police department. And the police don't seem to understand this concept of substantial hardship to the defendant. Now, for every time that I've had to go back and forth to Jefferson County, and if the police had thought about it because I've emailed them every day, yes. Did they think that, well, we're just going to have Paul pay for all these mental health evaluations? Right. We're going to have Paul pay for each and every one of the hearings. I'm going to charge him $10,000, $15,000. Right. And then we're going to find that he's mentally competent to stand trial. Thereby causing substantial hardship for having a public defender. Now, I had mentioned to the independent mental health professional, right, if the defendant is not ordered into competency restoration treatment, I would recommend an evaluation by a designated crisis responder, formerly DMHP. Due to his persistence that he has been wronged in his efforts to have contact with his sons. Do you think that I'm persistent in my efforts to have contact with my sons and that I have been wronged? Well, you didn't give any due process in 2011. You reissued a protection order where I was found not guilty in 2012. You served me 3 different ways, but then after the court hearing, you did not serve me until I had left the county. You reissued and modified the order when Greg Miller. And then you issued a protection order where there's no petitioner signature. Now, due to his persistence that he has been wronged and his efforts to contact with his sons, at the time of the evaluation, yes, Mr. Budnick did not present an imminent risk to danger to himself or others, but his desperation to gain what he feels has been unjustly lost may increase. Now, this recommendation of the designated crisis responder, Carol Kirk. Carol, as a designated crisis responder, when you know of the evidence that the accused didn't commit a crime, why is it that you didn't call the sheriff? At the time, Mr. Budnick did not present an imminent risk of danger to myself or others, but his desperation. Oh, the poor homeless man that's going to get stuck with $10,000 to $15,000 worth of court fees. Unjustly lost may increase. I had pointed that out to the psychologist, whom I've forgotten his name. Yeah. Really, what this says is, well, you're just a desperate, poor, homeless man that doesn't have any rights at all. Now, I don't remember putting a check here, but maybe somebody else did. Oh, ouch. I don't remember writing on this at all. I like to know who did that. Ouch. Do you think I'm delusional for not knowing what I've written and what I haven't? Now, I just wanted to know, okay, Jefferson County, what could you not possibly understand about not serving a third party? Yes. Not attempting service after I had been served in the Swim Public Library. The wrongful execution of the court order. Not requiring the petitioner to appear in court because she doesn't have to appear in civil court hearings. The use of the state court seal. The forgery of the ex officio elected oath of office. Exactly what the fuck, Carol? Now, Carol Kirk's going to prison. Do you understand, Carol? Now, why did the designated crisis responder not contact law enforcement about law enforcement having the evidence that I didn't commit a crime. Oh, see, there is no petitioner signature, and a petitioner has to appear in all civil court hearings. Yes. Inclusive of dissolutions of marriage. Yes. There was no actual notice of the hearing. Yes. The respondent was not present at the hearing because there was no notice. You issued this in 2011. Yes. Without any notice or opportunity to myself. Oh. And then there's the declaration of Heidi Budnick that you served me on Guam. Guam not being the jurisdiction of the protection order because you did not serve me. Then you reissued it. Oh. And you served somebody else. And you had a court hearing 50 days later after the reissuance of a temporary protection order where there was no attempt of service from 6/1 to 6/12. Happened to be outside the 90 days as allowed by law. Now, maybe Carol Kirk has some delusions about what the fucking law says. I don't have any delusions, and I'm not desperate to get my sons. But I'm telling every fucking oath of office in this nation that if you don't enforce the laws, you're going to prison. Now, do you feel that's desperate when I inform you of violating the laws of the United States? I show you the factual evidence, pooch, and you sit there on your laurels thinking you don't have to fucking do a thing.